Good morning and welcome to the Office of Tax Appeals. My name is Andrew Wong. I'm the lead administrative law judge who will be conducting the hearing in this case. On today's panel, in addition to myself, we have Judges Win Dang and Josh Aldrich. Also present is our stenographer, Ms. Lynn Alonzo. Because of ongoing concerns pertaining to the coronavirus and COVID-19, and consistent with the Governor's Executive Order N-25-20, the Office of Tax Appeals has decided that it is in the public's best interest to move the September 2020 calendar to remote electronic hearings. We are holding these hearings by video conference with the agreement of both the taxpayer and the tax agency's representatives, and this change will not impact the fair and objective hearing of tax appeals. This hearing is being conducted entirely electronically. All participants, including the ALJs, are video conferencing into this hearing. Should you have any problems with video conferencing during the hearing, please rejoin as soon as possible. If you are unable to rejoin the video number that you can call, and I believe you received that on your hearing notice. Barring any technical issues, the video conference will be live streamed to the public, recorded and posted on OTA's website as part of the public record. As part of the public record. Accordingly, please note that any information shared on screen will be quickly viewable. Our stenographer, Ms. Alonzo, will transcribe the audio of the hearing, and that transcript will also be posted on OTA's website. To help Ms. Alonzo make a clear record, I have 5 requests. Number 1, please state your name every time before you speak. This is especially important because some participants only have an audio connection. For this reason, we also ask that you do not use the chat feature in Webex. Number 2, please speak slowly, clearly, and directly into your communication device. Number 3, please do not speak over each other or interrupt when someone else is speaking. Number 4, please answer verbally. Do not nod or shake your head. Number 5, please mute your microphone if you are not speaking to avoid feedback and background noise. If Ms. Alonzo cannot hear, understand, or identify someone who is speaking, she has permission to interrupt the hearing at any time to get clarification. Speaking of clarification, I would like to clarify that this hearing is before the Office of Tax Appeals, or OTA. OTA is an independent agency separate from the California Department of Tax and Fee Administration, or CDTFA. As I noted earlier, I'm the lead ALJ for purposes of conducting this hearing. However, my co-panelists and I are co-equal decision makers and may ask questions of either party during the hearing at any time. Further, our panel of 3 ALJs will decide all the issues presented to us, and each of us will have an equal vote in making those decisions. Now, who is here for the appellant?
My name is Jacob Bola, representing the appellant.
Thank you. CDTFA?
This is Amanda Jacobs for the CDTFA.
And Scott Claremont for CDTFA.
And Jason Parker for CDTFA.
Thank you. When we go on the record, I'll be asking you again to identify yourselves and also spelling your names for the record. I have one issue today, and that is whether Portacath systems qualify as exempt medicines. Mr. Bola, is that correct?
That is correct.
CDTFA, is that a correct statement of the issue?
That is correct.
Okay. Appellant has submitted proposed exhibits 1 through 7. They had been labeled alphabetically, but that would be confusing because CDTFA's proposed exhibits are also alphabetical, so we relabeled them exhibits 1 through 7. CDTFA, do you have any objections to the proposed exhibits?
No.
Okay. Mr. Bullock, did you have any other documents or exhibits to add?
No, we don't.
Okay. CDTFA has submitted proposed exhibits A through. Mr. Bullock, did you have any objections to CDTFA's proposed exhibits?
No, we do not.
And CDTFA, you have no other documents or exhibits to add, is that correct?
Amanda Jacobs, that is correct.
Thank you. And thank you for identifying yourself before speaking, something I have forgotten to do. This is Judge Wong. Mr. Bola, you have no witnesses today, is that correct?
This is Jacob Bola. That is correct.
This is Judge Wong, CDTFA. You have no witnesses today. Is that correct?
Amanda Jacobs, that is correct.
Okay. Judge Wong, it's anticipated the oral hearing will take approximately 1 hour. These preliminary matters and introductions will be about 5 to 10 minutes. Appellant's presentation will be 15 minutes. CDTFA's presentation and closing remarks will be 20 minutes. And appellant's rebuttal and closing remarks will be 10 minutes. And I've budgeted about 10 minutes for ALJ questions if we need them. So appellant, you have 25 minutes total. CDTFA, you have 20 minutes total. Are there any final questions before we go on the record? Mr. Bolot? You're shaking your...
No, we do not. This is Jacob Ola.
Okay. Thank you. This is Judge Wong. CDTFA, any final questions?
Amanda Jacobs, no final questions.
Thank you. This is Judge Wong. Judge Dang, are you ready to go on the record? I think you're still muted.
Sorry, this is Judge Dang speaking. I'm ready.
Thank you. This is Judge Wong. Judge Aldrich, are you ready to go on the record?
This is Judge Aldrich. I'm ready to proceed.
Thank you. This is Judge Wong. Ms. Alonso, are you ready? Thumbs up. Thank you. All right. We are now going on the record. We're opening the record in the appeal of AngioDynamics Incorporated before the Office of Tax Appeals in OTA case number 19075004. Today is Tuesday, September 22nd, 2020. The time is 11:35 a.m. We are holding this hearing by video conference. The location for the record is technically Cerritos, California. I am lead administrative law judge Andrew Wong, and with me today are judges Win Dang and Josh Aldrich. We are the panel hearing and deciding this case. Individuals representing appellant, please identify yourselves and spell your names for the record.
My name is Jacob Bolan. That's J-A-C-O-B. Last name is B as in boy, H-O-L-A-T. Thank you.
This is Judge Wong. Thank you. Individuals representing the California Department of Tax and Fee Administration, which I will refer to as CDTFA, please identify yourselves and spell your names for the record.
This is Amanda Jacobs, A-M-A-N-D-A-J-A-C-O-B-S for CDTFA.
And this is Scott Claremont, S-C-O-T-T, last name C-L-A-R-E-M-O-N.
And this is Jason Parker, J-A-S-O-N, last name Parker, P-A-R-K-E-R.
This is Judge Wong. Thank you. We are considering one issue today, whether portacath systems qualify as exempt medicines. Mr. Bolot, is that correct?
This is Jacob Ola. That is correct.
This is Judge Wong. Thank you. CDTFA, is that a correct statement of the issue?
Amanda Jacobs, that's correct.
This is Judge Wong. Thank you. Appellant has identified and submitted proposed exhibits 1 through 7 as evidence. Appellant has no other exhibits to offer as evidence, and CDTFA has no objections to them. Therefore, appellant's proposed exhibits 1 through 7 will be admitted into the record as evidence. CDTFA has identified and submitted proposed exhibits A through D as evidence and has no other exhibits to offer as evidence, and appellant has not objected. Therefore, CDTFA's proposed exhibits A through D will also be admitted into the record as evidence. Appellant has no witnesses, and CDTFA also has no witnesses. Appellant, you have 15 minutes. Please proceed with your presentation.
Thank you. This is Jacob Ola, representing the appellant. Thank you for the time to present our case before this panel. The appellant sold permanently implanted catheters governed under Revenue Taxation Code Section 6369, Regulation 1591, and Regulation 1591.1, and collected tax from its customers. The claim for refund was denied by staff based on the language of Regulation 1591, Section B2, Paragraph 3. the application of this paragraph in question is unsupported by Revenue Taxation Code 6369, and the department's misinterpretation creates structural conflicts within the regulations and causes unnecessary confusion. The panel asked us to provide responses to questions from the pre-hearing conference discussion. We provided an extensive amount of product literature, medical information from renowned medical institutions, including the National Institute of Health and the National MPS Society. Also, we provided historical rulings dating back to 1978 that establishes a consistent administrative interpretation that the 6-month test has been the determining fact when distinguishing between a permanent and temporary implant. This consistent administrative interpretation of 6-month rule is a long-standing guideline for over 40 years and was established by the department and accepted industry-wide. The legal basis of using consistent administrative interpretation or construction can be found in numerous court decisions and rulings, which include Dell v. Superior Court 2008, GE versus the State Board of Equalization in 1952, and also in annotations 220.0211 in 1996, 220.0480 in 1994, 570.0480 in 1951. The panel also asked us to provide legal basis directing the OTA and CDTFA to accept the Board of Equalization's finalized decision to exempt these exact products sold by the exact same retailer on their October 2017 finalized decision, ruling in the appellant's favor. Section 15570.22 of SB 86, the Taxpayer Transparency and Fairness Act of 2017 states the following. All laws prescribing the duties, powers, and responsibilities of the board to which the department succeeds, together with all lawful rules and regulations established under those laws, are expressly continued in force. Expressly continued in force. That is a fundamental statement within the landmark legislation. California Code of Regulation, Title 18, Division 4.1, which provides the legal foundation for the Office of Tax Appeals. Section 30106 transferred the BOE jurisdiction to the OTA over all appeals heard after January 1st, 2018. All prior matters were legally decided by the BOE unless the decision was not finalized. Since the hearing was completed in October 2017 and thus finalized 30 days later, that decision should be accepted by both the CDTFA and OTA, becoming a part of Section 15570.22, which requires that lawful rules and regulations are expressly continued as in force as enacted by the legislator. Ignoring legal jurisdiction of the BOE at that time directly violates the legislator's intent under the Taxpayer Transparency and Fairness Act for continuity, fairness, and protecting taxpayers' rights, and fails to meet the legislator's direct guidance. Now I'd like to get into more information about the product. Permanently implanted catheters included in this refund claim are intended for long-term implantation and generally implanted between 2 to 6 years. You can find that in Exhibit 5. The implant is sutured in place at the port location beneath the skin. The vessel is punctured and the catheter is sutured in place where the catheter enters the vessel system. Thus, the entire implant is tied into the vascular system as illustrated in Exhibit 4. Based on Exhibit 3, ports are implanted for patients who require long-term access. These patients are at high risk of collapsing veins and vessels and also infection. The damage would impair normal blood flow in the overall vascular system. The products assist the vascular system by reducing risk from occlusion, which is clotting, blockage, and or collapse, so that the blood can continue to flow normally, which is the primary function of the vascular system. The needle no longer enters the vessel or vein, thus protecting and assisting the patient's vascular system for normal function. It also reduces the risk of infection for patients who require consistent access to their vascular system by providing an alternative safe access point, which is extended from the vessel to the skin. This product is surgically implanted in a separate procedure. Our claim only includes items that were implanted. Any items that are from the skin to the outside of the patient's body are not being claimed. Our basis for exempt treatment. In 2017, the board clearly decided that these items are exempt from tax as permanent implants. The following logic was applied and should be continued in force to conclude that these items should remain exempt qualified permanent implants, supporting the legislator's intent for continuity. First, the device has been considered to be permanently implanted if its removal is not otherwise anticipated for more than 6 months. All parties agreed that these products met that qualification both in the BOE 2017 hearing and all prior appeals related to both cases. Second, Revenue Taxation Code 6369 exempts as medicines permanently implanted items that assist the function of the body. Merriam-Webster's defines assist as to give, support, or aid. Another definition is an act or action that helps. Assist does not mean replace. The decision provided by appeals takes an unsupported narrow application of the assist the function concept that is not supported by regulation or law or the accepted definition of these words. The decision claims that unless the catheter conducts blood flow, it does not assist the human body. This concept has no basis within the law section or regulation. Regulation 1591 exemptions include tissue markers, IV and enteral feeding tubes, integral related bags, tubings, filters, locks, tapes, clamps, connectors. Also exempted are wigs and hairpieces under a prescription. All of these items and many numerous others qualify to support and or assist the human body within the same regulation. Why then would an implanted catheter used to stabilize and protect the patient's vascular system be excluded? These exempt products listed contradict the mistaken These exempt products contradict the mistaken decision's narrow application of assist and or support. The appeals decisions conduct blood flow has no basis in law, regulation, or administrative interpretation. Annotation 425.0724, which provides a similar logic, again provides no legal foundation. The department relies on the annotation excerpt, but fails to fully evaluate the prevailing law section 6369 and 2 regulations. In fact, the backup letter published on the CDTFA's website only provides an analysis of the PortaCap product to a programmable drug infusion device and has no mention of any analysis on the permanent implant application. The published annotation doesn't have any backing of the full response from legal. They likely don't want to publish this because they have no legal basis for this flawed logic. Again, there is no detailed analysis of the permanent implant language. It is simplistic analysis. It is a simplistic analysis with no basis in law related to the concept of permanent implants, yet it's being used as a basis to the department's argument. Regulation 1591.1, lowercase b, 4, uppercase b, exempts catheters which are permanently implanted in the human body and assist the function of a natural organ, artery, vein. This item is a permanently implanted catheter which assists the arteries and veins or vascular system. This regulation 1591.1 clearly exempts this product with no question. The department's misinterpretation of Regulation 1591 creates a major application issues. Regulation 1591, subdivision B2, unnumbered paragraph 3 states the following. Implanted articles do not qualify as permanently, in quotes. Implanted medicines include, but are not limited to, and then it lists temporary implants, including the PortaCap system. Language under subdivision B2, paragraph 3 specifically emphasizes the word permanently in quotation. This language can be interpreted 2 different ways. The language specifically excludes the items listed in the paragraph, which is the position of the department, disregarding the emphasized permanent in quotes, or 2, it excludes items which are temporarily implanted and should not be taken as a 100% list, which is also clearly stated in the paragraph. The quotation marks are added as an emphasis to exclude only temporary items, which is our position and consistent with the balance of Regulation 1591, Regulation 1591.1, and Revenue Taxation Code 6369. If the sentence is read by itself without taking into consideration other parts of Regulation 1591, Regulation 1591.1, and Revenue Taxation Code 6369, then there is a large construction issue with the regulation in a never-ending circular reference. One place it says taxable when taken out of context, two places it provides a clear exemption. Why do we have this problem in this regulation? The list of examples in paragraph 3 included items that were not permanently implanted at the time the section was added. Pages 7 to 11 of Exhibit 6 provide a historical timeline of the development of this technology. Not until the 1980s was a port implanted permanently for long-term use. So after this period, this paragraph's list of items which included port of caps became obsolete. The board addressed this issue to correct it on 2 occasions. However, the department continued to violate the legislator's intent by ignoring these direct mandates. Today, the port of cap systems included in this claim are permanent implants and assist the natural function of the artery system within a patient requiring long-term care in order to prevent long-term difficulties associated with collapsing veins and arteries, damage to their blood system, and increased risk of infection and a better quality of life. Next, I would like to go through the historical application of permanent implants. I have served clients in the healthcare industry for over 20 years. Since 2001, higher level decisions on products that were implanted have 100% of the time been determined that permanently implanted items qualify as exempt medicines, going against the department's various historical positions. In every case, products deemed taxable by the department were exempted by the higher levels. This list includes dental bone screws and abutments, cochlear hearing implants, including external integral components, cosmetic implants, regardless if the procedure is selective or is reconstructive, and most recently, monitoring devices and breast tissue markers. Also, in 2017, after an extensive analysis and discussion of this product was determined to be exempt. However, the department chose to ignore that decision. In November 2014, the Business Tax Committee held a board meeting in response to the cases related to the breast tissue markers. The treatment of the permanently implanted port of caps was discussed along with the regulation revision. This product was brought up because at that time, those items were being held in abeyance by the department pending the regulation revision. Based on the Business Tax Committee minutes, this exact paragraph, section B2, paragraph 3, was modified, and the sentence that stated that these items in paragraph 3 are taxable was removed. This was a step forward in the right direction to remove the conflict. However, it was not enough. The board recognized this issue and asked the department to provide clarification in the audit manual, which was never done by the department. In conclusion, we respectfully request that the OTA determine that port of caps are exempt permanent implants qualified under Revenue Taxation Code 6369, Regulation 1591, and Regulation 1591.1. This will also carry through the legislator's intent for continued fairness by accepting the BOE's accurate, rightful legal decision, and it will guide the department to correct the inaccurate language in Regulation 1591B2, paragraph 3. This paragraph should be modified to clearly guide the segregation of temporary versus permanent. The list of examples needs to be modified to remove this product. Now that it's confirmed as permanent, this language should be updated also to clarify that this paragraph only applies to temporary implants. Thank you. This concludes my opening statement.
This is Judge Wong. Thank you, Mr. Bulot. I will now turn to my panel to see if they have any questions. Judge Aldrich, do you have any questions for appellant?
Yeah, I have a couple of questions. You referenced a prior claim, and I understand that's the claim that was filed April 25th, 2012. Is that correct? I can't hear you. I'm sorry, you muted yourself.
Could you repeat that question, please? I didn't hear you very clearly.
Okay, so during your opening argument, you referenced a prior claim that went to decision and ultimately to a hearing And are those the decisions and hearing notes referenced in the exhibits? So I have that as a decision issued August 9th, 2016, with a hearing date of October 24th, 2017.
That was a Board of Equalization hearing in October of 2017.
Yeah. Is it your position that that is a precedential decision, or is it not?
I don't think we tried to address that question. I think we bring it up and reference it because the higher body decided that. I think our position is that if you look at the way the legislation was set up, there was the concept of continued to enforce. And so when you look at the legislation to enact the department's structure and the OTA structure, there was a transition that was made. And the October 2017 decision was finalized. And within that decision, which is the public decision, there is also guidance to the department to take corrective action. However, that never was taken. So clearly the board, which had the legal right to make that decision, directed the department to make corrections and ruled in our favor. Whether there's a direct legal answer of, yes, this is an absolute decision and you have to follow it, I'm not qualified to make that decision. But I think what we've done is presented as much facts as we can in information and laws and rules that support the position that that decision should have been carried forward.
Okay. Thank you. No further questions at this time.
Judge Wong, thank you. Judge Dang, do you have any questions for appellant?
This is Judge Dang. I do have one question for you, Mr. Bullitt. I'm wondering if you could please show me where in the record it demonstrates that the portacath is indicated for patients with either collapsed veins or some other form of a blood flow issue.
So you're looking at a situation where it is so you have a patient who has a long-term access requirement. And you have a situation where the medical staff understands that this person is going to have repeated access to the vascular system. So this is a implant that's put in place as a preemptive measure to avoid that, generally. Now, if a patient has already a collapsed vein or has that issue, they're going to put that in. However, I don't think the product literature says, oh, you should put this in after the fact. It's put in, generally, it's put in as soon as they determine that this person is going to need repeated long-term access.
Thank you, Mr. Bullitt. So just to make sure my understanding is correct, this is more of a preventative measure. So it assists in the sense that it prevents issues from continued access to the vein or artery. But it's not, in essence, a medicine to correct pre-existing conditions for that.
Sorry, this is Jacob. I would say yes, but I also would say it's not a situation where they're not gonna, if there's already a damaged vessel, they're not gonna not put it in. So if the patient is already having problems and they put in the port after the fact, that's still the same scenario. It's going to be that patient needs continuous access for long periods of time. And so the reason why they put it in is to avoid that damage. Because once the damage occurs, now you have a problem where the vascular system no longer functions properly. So therefore, sorry.
I'm sorry. Thank you. This is Judge Dang again. So would it be fair to say, in your opinion, that another use of the catheter is access to the artery or vein? The more permanent access?
Is it a very, it is a part of the process, I would say yes. I think that to look at it and say it's only an access point would be unfair would be a misrepresentation of the true intent of that product. The true intent of the product is to make sure that the patient has proper blood flow through their body. And they go through a special procedure of implanting this in a separate procedure. It's not part of like when a patient is in the bed, they'll take them in to have a separate procedure done. They'll do the implantation. They suture the items into the skin. They suture the item into the catheter, or into the vessel where the catheter enters. So they're sealed in both places. And so it's basically a connection or an extension of the vascular system to the skin. And so at that point, rather than the needle going directly into the vessel where it's going to cause damage, the consistent access to it is going to cause it to damage. It's going to cause it to collapse. And so what they'll do, the whole concept of this product is to protect the vascular system so that when they have the access point, which is a flexible rubber cover, it's probably silicone, but every time it's accessed, it self-heals, it self-closes. And so it's basically an extension from the vascular system to the skin.
Thank you so much. I have no further questions at this time.
This is Judge Wong. Thank you. I had one question for appellant. Mr. Bullock, the board decision that you're referencing involved the same taxpayer, same product, but was it for a prior claim period? It's not the claim period at issue, is that correct?
This is Jacob Bullock. I apologize. I forgot to announce myself. Yes, that is correct. It was for the prior, I think, 2 or 3 year period to this claim. And the exact same product, exact same customer, exact same vendor. Everything was exactly the same.
This is Judge Wong. Thank you. I have no further questions. Now we turn to CDTFA for their presentation. They have 20 minutes. You may proceed.
This is Amanda Jacobs for CDTFA. Appellant is seeking a refund of sales tax reimbursement collected and remitted to CDTFA on behalf of its customer, the University of California, San Francisco Medical Center, or SFMC, on its sales of port catheters, or portacats. It is undisputed that the medical devices were purchased by SFMC and that appellant charged and collected sales tax reimbursement from SFMC on these sales. It has never been disputed that catheters were used for drug infusion. Therefore, the only issue is whether portacats, when used for drug infusion, qualify as medicines for purposes of the exemption. Under the Revenue and Taxation Code, Section 6012 and 6051, sales tax applies to a retailer's gross receipts from the retail sale of tangible personal property in this state, unless the sale is specifically exempt or excluded from taxation by statute. Section 6369, which is interpreted and implemented by Regulation 1591, exempts from sales and use tax the gross receipts from the sale of and the storage, use, or consumption of medicines, as defined, if they are dispensed or otherwise provided to the patient under certain specified circumstances. As relevant to this appeal, 6369B excludes from the definition of medicines articles that are in the nature of splints, bandages, pads, compresses, supports, dressings, instruments, apparatus, contrivances, appliances, devices, or other mechanical, electronic, optical, or physical equipment or article or the component, parts, and accessories thereof. However, 6369C provides exceptions to that exclusion, including permanently implanted articles that assist the functioning of a natural organ, artery, vein, or limb, and which remain or dissolve in the body. Regulation 1591B2 further clarifies this exception and specifically states that portacat systems used for drug infusion purposes, quote, do not qualify as permanently implanted medicines, end quote. Statutes granting a tax exemption are strictly construed to avoid enlarging or extending concession beyond the plain meaning of the language used in granting it. See Associated Beverage Co. versus Board of Education, 1990, 224 Cal App 3D 192. There's the burden of showing it clearly comes within the terms of the exemption by a preponderance of the evidence. See Regulation 35003, Subdivision A, and Payne State versus State Board of Equalization, 1982, 137 Cal App 3D 438. Here, The port catheters sold by appellant were used for the purpose of drug infusion. Regulation 51B2 categorically states that portacath systems used for drug infusion purposes do not qualify as permanently implanted medicines. This is consistent with several other definitions set forth in 1591B, including orthotic devices in B4 and prosthetic devices in B5, which also list items that do or do not meet the definition. There is no difference here. This provision is not subject to an interpretation that portacaths used for drug infusion purposes could meet the definition of medicines under subdivision B2. Therefore, it is not necessary to assess whether these devices fail to meet a specific element of Regulation 1591B2. The department must be faithful to its own regulations, which are quasi-legislative and have the force and effect of law. See California Teachers Association versus California Commission on Teacher Credentialing, 2003, 111 Cal App 4th 1001. Furthermore, as the Office of Tax Appeals has recognized in its precedential opinion in the matter of the appeal of Alfred J. Talavera, OTA does not have a to declare a CDTFA regulation invalid or refuse to follow it. Case number 180-11885. These facts alone are sufficient to deny appellant's claim. However, to address appellant's contentions today and to respond to the panel's request made at the pre-hearing conference, we will discuss the specific elements of the definition set forth in 1591B2. Revenue and Taxation Code 6369C2 states that medicines include articles permanently implanted in the human body to assist the functioning of any natural organ, artery, vein, or limb, and which remain or dissolve in the body. Regulation 1591B2 clarifies that an article is considered to be permanently implanted if its removal is not otherwise anticipated. Thus, to be considered permanently implanted for the purposes of the exemption, the medical device must both, 1, assist the functioning of any natural organ, artery, vein, or limb, and 2, remain or dissolve in the body such that its removal is not anticipated. As to the first element, the device at issue fails. When used for the purpose of drug infusion, a portacath does not assist the functioning of a natural organ, artery, vein, or limb. The purpose of a vein is to conduct blood flow. According to the materials appellant provided, the purpose of a portacath is to act as a portal into the vein for ease of access into the vascular system. In Appellant's Exhibit 3, page 21 of the exhibit binder, and highlighted by appellant, we find the port catheter is inserted into a blood vessel to deliver therapy from the port body into the bloodstream. Dispersal of drugs is not the vein's natural function. Later, on page 23, the literature states that the most frequent use of the port is for, quote, vein access. It defines this as a way of entering certain blood vessels in the body. Intravenous access is not a natural function of the human body. As such, portacath systems used for drug infusion purposes, whether they remain or dissolve in the body, would be excluded from the definition of medicines under subdivision B2 because they do not assist the functioning of any natural organ, artery, vein, or limb. This has been the long-standing position of the department, as evidenced by annotations 425.074 and 425.0247. Appellant argues that portacath systems used for drug infusion purposes were explicitly excluded from Regulation 1591B2 only because they were deemed to be implanted for less than 6 months. These annotations, which predate the amendment adding the specific exclusion of portacath systems, show that this is incorrect. The panel requested we address whether portacaths are permanently implanted and whether sales and use annotation 425.0163 applies in this case. We presume the panel wants us to address the second element of 1591B2, whether this device remains or dissolves in the body such that its removal is not anticipated. Appellant's device appears to be intended to remain in the body beyond 6 months. However, as already discussed, portacaths are specifically excluded as a permanently implanted device by regulation. And even if they were not specifically excluded, In order to qualify as a permanently implanted article for purposes of the exemption, the device must meet both elements, which this device does not. Finally, we have provided the rulemaking documents for the most recent amendments to Regulation 1591, and specifically Subdivision B2, including the second discussion paper and formal issue paper 14-006 as Exhibits C and D. These exhibits show that Mr. Bolat recommended amendments to the final paragraph of Regulation 1591 B2, the paragraph in which portacath systems are specifically excluded from the exemption. His recommendation included both a suggestion to remove the specific exclusion for portacath systems used for drug infusion purposes and to add an additional phrase to B2 indicating items specified as not constituting permanently implanted medicines are taxable only, quote, if intended for temporary implantation, end quote. See Exhibit C, PDF pages 114 and 135 to 136, and Exhibit D, pages 161 and 164. In other words, Mr. Bolat amendments that would have made explicit what he is arguing today. His recommendations were rejected by the board. In assessment of his proposed amendments and consistent with annotations 425.0724 and 425.0247, the issue paper states, quote, some of the items listed in the paragraph, that's the final paragraph of 1591B2, fail to meet the definition of medicine contained in subdivision B2, not because they are not permanently implanted, but because they do not assist the functioning of a natural organ, artery, vein, or limb. See Exhibit D, page 161. Appellant argues that these items support the natural functioning of arteries, veins, and blood vessels by providing support so they do not collapse or become damaged, and therefore argues that they do functioning of a natural organ, artery, vein, or limb. We note that Regulation 1591B2 specifically states that portacath systems used for drug infusion purposes do not qualify as permanently implanted medicines. Therefore, it should not be necessary to assess whether these devices fail to meet a specific element of 1591B2. However, a review of appellant's product materials also shows that the only reason the veins would become damaged or collapsed is through repeated access to the bloodstream, and the purpose of a portacath is to allow repeated access without damage. Again, intravenous access is not a natural function of the human body. Appellant references other devices, such as breast tissue markers. However, while portacaths are specifically excluded from subdivision B2 by definition, breast tissue markers are specifically included, as also explained in Exhibits C and D. Also argues that the removal of the former sentence, quote, the sale or use of these types of items would be subject to tax, end quote, from subdivision B2 could allow this product to be exempt. However, as Exhibit D shows, that sentence was removed to clarify that the specific articles that do not qualify as permanently implanted medicines under B2 may meet the definition of medicines under a different subdivision. See Exhibit D, pages 158 and 161. Removal of that sentence had no effect on the applicability of subdivision 2 to those items. Finally, as requested by the panel, we address whether OTA is bound by any prior Board of Equalization decision in this matter. To be clear, there has been no prior Board of Equalization decision in this matter. We presume this is a reference to the BOE's October 24th, 2017 oral hearing related to a refund claim for the period January 1, 2009 through June 30th, 2011. That matter is not before us today. This is a new refund claim for a different period for tax different transactions. Therefore, OTA has jurisdiction to hear and decide this appeal with the authority granted to it by Rules for Tax Appeals, Section 30103, Subdivision B. Appellant presented argument why the board's decision should be accepted by CDTFA and OTA and references Government Code Section 15570.22. However, this is not a matter of continuing lawful rules and regulations. nor is this a matter of overturning a prior decision by the BOE. Furthermore, an administrative decision, even one involving the same taxpayer, may not be relied upon as precedent unless it is so designated by the agency. See Government Code Section 11425.60, Subdivision A, and Sheet Metal Workers Association, International Association, Local Union Number 104 versus REA, 2007, 153 Cal App 4th 1071. Even former Section 5551B4 of the Rules for Tax Appeals, in effect at the time of the 2017 oral hearing, stated, quote, non-precedential opinions may not be cited as precedent in any manner or other proceeding, end quote. No precedent opinion followed the October 24th, 2017 oral hearing. As such, the outcome is not precedent and by law cannot be relied on as such. Note that in the 2017 hearing, the board failed to follow its own regulation as it was required of it by California law. Newco Leasing Incorporated versus State Board of Equalization, 143 Cal App 3D 120, Insight 124, which states the BOE's interpretation of the legislative will must be reasonable and the board must be faithful to its own regulations. In summary, the port catheters sold by appellant were used for the purpose of drug infusion. Regulation 91B2 unambiguously states that portacath systems used for drug infusion purposes do not qualify as permanently implanted medicines. Even if they were not specifically excluded by regulation, they do not assist the functioning of a natural organ, artery, vein, or limb. Therefore, portacath systems used for drug infusion purposes do not qualify as medicines for purposes of the exemption. Appellant has not burden of proving these transactions are entitled to exemption from sales tax, and a refund is not warranted. For these reasons, we request the appeal be denied. Thank you.
This is Judge Wong. Thank you. I'll now turn to my co-panelists for any questions for CDTFA. Judge Aldrich, do you have any questions?
Do not at this time. Thank you.
This is Judge Wong. Thank you. Judge Dang, do you have any questions?
This is Judge Dang. I do have a question for you, Ms. Jacobs. The second sentence of subdivision B2, it states that an article is considered to be permanently implanted if its removal is not otherwise anticipated. You had mentioned on several occasions that CDTFA must be faithful to its own regulations. I'm wondering if perhaps you know the rationale for why, for the policy or CDTFA's position today that something is permanently implanted if if it's anticipated to remain in the body for a period of at least 6 months, given the language here in this subdivision.
I'm not sure I understand the question.
This is Mr. Claremont. I think as a general principle, often a 6-month timeline is substituted for a law that sets forth a permanent or no timeline at all. For instance, when something's being presumed to be used in California, it's generally the rule of thumb we use colloquially is forever equals 6 months, basically. So often you will see a 6-month test applied to a timeline that's essentially permanent.
This is Judge Dang speaking again. Thank you for that explanation. Would it be appropriate to use a colloquial, as you put it, definition when it appears we have a technical definition here in the regulation that permanent means no removal anticipated?
Yeah, I'm not sure about the question of appropriateness. As the annotation states, the general rule is that if something is intended to remain in the body for more than 6 months, we consider it to meet this test. but I don't know if we can respond to the appropriateness of that annotation.
This is Judge Ding. Thank you for your response. I don't have any further questions at this time.
This is Judge Wong. Thank you. Now we turn back to Mr. Bolat for rebuttal and closing remarks. You have 10 minutes. You may proceed.
Thank you. This is Jacob Bolat. So first, I wanted to address some of the items that Ms. Jacobs brought up. I don't think we in any way have any intention of contradicting or questioning the OTA's jurisdiction in this case. We do cite that prior case, again, because it is the exact same product, exact same customer, exact same retailer. The only difference is the period of time. Due to the transition, that October 2017 board decision was not afforded the time to update the regulation. However, when you read the language of the discussion of the board members, they actually advised the department that they should take this matter up and to further make clarifications in the regulation. However, because of the transition of power, that process was never taken up. Related to the breast tissue markers that Ms. Jacobs cited as being specifically in the regulation, that regulation update was done because of a board decision where it exempted the product. And in that situation, the department argued that because that marker, all the marker does is it's placed inside the human body, it is marking a location, and that's all it's done. It's done in cancer patients, so that when the physicians or medical staff goes back to evaluate future changes of the cancer and evaluate the status of it, they know where that cancer was located. So clearly in that decision, that also supports that the permanent implant in itself should be deemed to be exempt. The Ms. Jacobs' assertion that in the 2014 regulation revision that our recommendations were rejected is partially true. We recommended that the regulation be revised to exclude that product from the list of temporary implants. However, the board didn't deem that they had the jurisdiction in that situation to make that decision. So what they did do was they did strike out the sentence that says these items are subject to sales tax to provide clarification. They also asked and requested that the department make revisions in the audit manual to help provide clarification. Again, that was not done. Further backing up their position, in 2017, 3 years later, their analysis in this same scenario with these same products when we brought them up was to rule in favor of the appellant. So clearly their recommendation, their decision was that anything permanently implanted is exempt from tax. The board's slicing and dicing of what is and is not accurate. The other thing that I would like to point out, which is a language issue that Ms. Jacobs used in her reading of Revenue Taxation Code 6369, Section C2. It says, Section C says, notwithstanding subdivision B, medicines and as used in this section mean and include any of the following. And I'm reading this specifically out of the language. It says, bone screws, bone pins, pacemakers, and other articles other than dentures permanently implanted in the human body to assist the function of any natural organ, artery, vein, or limb, which remains or dissolves in the body. In her presentation, she split the word natural in the position of the word natural. Her argument is that it doesn't assist the natural function. That's not what the law section says. It actually says the natural organ. So it doesn't say that it has to assist the natural function. It only has to assist any function within the body. I think that the department's continued argument that it has to conduct blood flow is clearly not supported in anywhere in the regulation, anywhere in the law section. In fact, that position contradicts everywhere else in Regulation 1591. And in fact, 1591.1 specifically exempts permanently implanted catheters with no exception. So if you take the department's position that, well, because it's specifically the language taken out of context in paragraph 3 of B2 is taken out of context, it says this item is taxable, well, then it conflicts directly with 1591.1. It conflicts directly with the Revenue Taxation Code 6369. It conflicts directly with Regulation 1591, Section D, the first part. And the definition of permanent, I think we've already gone through. I don't think anybody argues that. So when we look at their analysis, they keep coming back to, well, it's specifically excluded. However, when you read that paragraph, the words permanently are in quotation marks. And that is to provide an emphasis. And the emphasis is that items that are not permanently implanted are subject to tax. Nobody argues with that position. If it's in there for less than 6 months, it doesn't qualify as an implant. It may qualify somewhere else, but it doesn't qualify as an implant. When you look at all of the items listed in that paragraph, all of them are temporary implants. At the time, they were all temporary implants when that section was added to the regulation. However, as we pointed out in our presentation earlier, in the 1980s, that technological evolution changed. And so therefore, that portion of leaving that item in that list became obsolete. And so it needs to be removed, which is what we've been trying to do for the last 4 years or 5 years. And so when we look at that, the only revision that needs to be made in the regulation, in my opinion, and I've been doing this for a long time and I analyze tens of thousands of products, and that is that product needs to be removed because it's no longer a temporary implant. That section and that paragraph needs to be strengthened to clearly establish that permanent implants are exempt and temporary ones are not. And that's what that caveat of that paragraph should be at. Give me a second here. I change gears. So what I wanted to do is to again go back to the structure of Revenue Taxation Code 6369. And in that section, the ultimate goal is defining a permanent implant. And that language, as I read earlier, provides a very clear description of a permanent implant. It says, notwithstanding subdivision B. And then it goes to list bone screws, bone pins, various other things. Permanently implanted in the human body to assist the function of any natural organ, artery, vein, or limb, and which remains or dissolves in the body. The department's decision discusses standards to meet that term, permanent. Within the language of the law, there is no distinction, qualification, or exemption to permanently implanted items that is administered to a patient under prescription other than dentures. They only have one exclusion. They define permanent, they say permanently implanted is exempt. The only exclusion they give is dentures. The law section uses the term notwithstanding subdivision B, which defined in the dictionary is as in spite of, which again clearly indicates the legislator's intent to exempt all permanent implants, ignoring subdivision B's limitations when it comes to a permanent implant. The application of Regulation 1591 B2 paragraph 3 should be construed only to exclude temporary implants and nothing else. As Judge Dang had said asked question earlier, if an item is permanently implanted, it goes into the spirit of the law that item is an exempt medicine, period. The term permanent has been agreed and accepted at 6 months or longer. The examples in the regulation language paragraph 3 were used to illustrate potential temporary products at that time. This should not include an implanted item that remains in the body for more than 6 months through technological evolution. Now that the product has changed, it should be removed from that list. The position to tax a permanent implant is not supported by the law section 6369 in any way possible. Whatever the regulation says, the law section is clear. The department has conceded for over 4 years since this case has started that these portacaps are implanted for more than 6 months. Thus, they are permanently implanted in the patient. I already went through all this. I'm reading through my notes, so forgive me. The discussion during the VTC to remove that specific sentence where it stated the items are subject to sales tax, that's an important step forward because it helped provide clarity to the application of that paragraph within the regulation. But the department didn't carry through the mandate to provide further guidance in the audit manual. Again, the lack of any exceptions in law section 6369 and the language clearly indicates that any item qualified under regulation 1591 or 1591.1 and implanted for more than 6 months meets the exemption of a permanent implant. Finally, and I know we said this over and over again, there is a major conflict within the regulation 1591 and 1591.1 if this paragraph is taken out of context, as the department does attempt to do so.
Mr. Bullock, sorry for interrupting. Your 10 minutes are up. If you could just finish up. I know you said finally, but I'll give you like 30 seconds to finish up.
Perfect. Regulation 1591 clearly exempts permanently implanted catheters. Regulation 1591.1 clearly exempts permanently implanted catheters, no limitations, no exceptions. The only exception is dentures, and that's it. Paragraph 3, when taken out of context, it creates a conflict within the law and within the regulation, within regulation 1591.1, and it makes no sense when it's applied the way the department is applying it. Thank you again for the presentation and the extra time.
Thank you, Mr. Bullock. This is Judge Wong. Now I'll turn to my co-panelists for any final questions. Judge Aldrich, do you have any questions?
This is Judge Aldrich. I don't have any final questions.
This is Judge Wong. Thank you. Judge Dang, do you have any final questions?
This is Judge Dang. Thank you, Judge Wong. I do not have any final questions.
This is Judge Wong. Thank you. I also have no final questions. Accordingly, this concludes the hearing. The record is closed and the case is submitted today. The judges will meet and decide the case based on the exhibits presented and admitted as evidence. We will send both parties our written decision no later than 100 days from today. The hearing is now adjourned, and hearings for today are adjourned until tomorrow at 10 a.m. Thank you all. And now we're off the record.
Thank you.
Thank you very much, Your Honor.
Thank you, guys.